For most people, their house is their biggest asset. Is that a countable resource? No, it is not. You can keep your house. Some people say, well, isn't there, limits on how much the house is worth? If you are in a couple situation, there are no limits. As long as one of you is living in the house, there are no limits to what your house is worth. If you are a single person, yes, there are limits. In the state of Washington, the equity limit for a single person currently is $1,033,000. That is the federal max standard. So if you live in King County and you are a single person, potentially your house is worth more than $1 million in equity. If that's the case, you're going to need to see an elder law attorney who is going to help you with strategies to draw down your equity such that your house doesn't count against you. So I do want to mention that one of the reasons that Medicaid is so confusing and complicated is that there are so many exceptions to the rules. I'm going to cover a lot of them. My hope is that I don't confuse you. I want to shed light on this subject and give you more information. One of the things primarily, especially if you're a single person, is I don't want you to think that you have to spend down all of your money, that you have to sell your house, that there's no other options for you. I can't give you legal advice in this forum, but what I can do is give you enough information, plant that seed in your head that you know that if you are a single person and you're looking at long-term care, see an elder law attorney that understands Medicaid strategies, because through Medicaid asset preservation strategies, we are able to preserve a lot of your estate. Now, the topic today is no Medicaid spend down. Couples, that's more for you, because with couples, we have more tools available that allow you to keep all of your money. Obviously, if you have multi-millions of dollars, you are not looking at qualifying for the Medicaid program. But folks with a modest amount of money, and modest could be $500,000 in your bank, $500,000 to $1 million in your house or beyond. Those are the folks that we are talking to say, if you are a couple and if that's your situation, we can preserve all of your assets without you having to spend it down. All right, let's go back to talk about, well, what is counted? We just talked about the house. The house doesn't count against you unless you're a single person and you have quite a lot of equity above $1 million. Even so, there are exceptions to the rule. If, for example, you have a disabled child who lives with you, a blind child, a child under the age of 21, the equity limit doesn't count. So that's an important question that your attorney will ask you if your home, for example, is worth $2 million. So what else doesn't count? What I want you to think about, just kind of as a general rule, is that you start from the premise all assets count unless I tell you they don't. So your house doesn't count. What else doesn't count against you for Medicaid eligibility? A vehicle does not count, regardless of what the value of that vehicle is. It can be your 100,000 whatever vehicle. It doesn't count against you. Anything that you have in your home, any of your personal effects, everything that you have that's considered personal property does not count. Now, if you have titled other vehicles or a titled, you have your car and you have your RV, that's a titled asset, that's going to count. So when I say personal property, I'm talking about things that don't have titles to them. What else doesn't count? Oh, and by the way, your personal effects could involve your artwork, your jewelry, your musical instruments, anything along those lines. So you don't need to get rid of and sell all your stuff. What else doesn't count? A burial plot, burial urn, a space is exempt regardless of the value. Amounts to cover your burial expenses don't count. There's a couple of different options with that. You can have a burial fund, but it's only limited to $1,500. Or instead, what we typically will recommend to clients is that they have an irrevocable burial plan of a reasonable value. Well, what's reasonable? Well, it depends upon what your situation is. You know, a $10,000 plan can be very reasonable if it's an irrevocable plan. So there are ways to make sure that you put your money to good use, to have things in place, because when you pass, then your family won't need to pay for any of that. You've already purchased it in advance, and Medicaid allows you to do so without counting that asset as interfering with your benefits. This life insurance exemption is kind of laughable in that life insurance Medicaid allows you to keep can't have a face value greater than $1,500. So let's say, I mean, that obviously is intended more to cover burial expenses. So if you have a term life insurance policy, the death benefit can be unlimited because a term policy has zero cash value. But if you bought a life insurance policy as an investment vehicle and it's worth $10,000, $50,000, $100,000, whatever it may be, that is a countable resource. Sales contracts, if you have certain sales contracts, they will not be countable. There's something called a long-term care partnership insurance policy. And if you have something like that, I believe all the policies sold now in the state of Washington would comply with this requirement. Let's say you have such a policy and it pays a benefit for your long-term care of $100,000, then you'll be allowed to keep an extra $100,000 because you bought a policy that will provide for your care up to $100,000. Another exception to what counts is if you cannot convert an asset in 20 days to cash, it is disregarded and it is not counted. That provides a lot of planning opportunities for a couple in particular, but also for a single person. And then one of the biggest tools that we use as Medicaid planning attorneys is an annuity. Now, it's a Medicaid compliant annuity. So if you have a typical annuity that your financial planner advised, if you thought was a great idea, that annuity counts. So an annuity that doesn't count is one that complies with Washington's strict requirements, which includes that upon your death or the death upon your death, that it will pay back to the state for benefits that were paid on behalf of your spouse. So if you're listening, unless you are working with an elder law attorney and know you have a Medicaid compliant annuity, your annuity is not Medicaid compliant and it counts as a resource. So those are the things that don't count against you.